Good afternoon, this is Jane Sanders, Director of JSCS, a claims management company, specialist lawyer and unregistered barrister. As some of you may know, if you've been watching any of the videos either on Facebook pages or this new YouTube channel, I'm involved with a group of caravan owners that reside around the UK that are either owners of a caravan as a second property or they are used as their main residence. There are two petitions in place at the moment. Unfortunately, it would seem that Parliament, for very good reason, has ground to a relative halt with regards to actioning any of the things that are being requested under the parliamentary route. Please excuse the noise in the background. The second is a petition that's been created deliberately to avoid the need to fall into a parliamentary queue. And as I said and have said on previous feeds, certainly on Facebook, there is certainly an awful lot of angry and vitriolic comments and bad feeling amongst the community that represents the UK caravan holders for good reason. The purpose of today's video is to give you legal interpretation of the guidance that's been issued and the new statute and statutory regulations that are in place now. One of the key issues that's been brought to my attention prior to yesterday's update from Park Holidays was, oh my God, this is very serious now. We're on lockdown, according to our Prime Minister. What does this mean? Where do I go? Can I stay in my caravan? Prior to the lockdown, it had become very much a cause for concern amongst the caravan community that those that were trying to self-isolate in order to comply with the government guidelines, in order to minimise the risk of the spread of coronavirus, were in fear for their ability to actually stay in their caravans because the rumour mills started spreading that you would be asked to leave your site if you were found to be self-isolating. Of course, with the advent of social isolation and what I will refer to as a legitimate lockdown, even though that lockdown may not be as severe as in other countries, we now have a situation where guidance has had to be issued at the highest position in the land and with immediate effect, for the simple reason that our whole economy is going to have to be slowed in order to minimise the risk of this virus being transmitted. Now, first of all, I would invite you once again to sign the petition prepared by Keith Whitehouse. As I said, and will continue to maintain, we have access to a number of politicians who have very kindly lent their ear to this this issue, and it is a very big issue. We think over 250 million people actually have, a 250,000 people actually own caravans around the UK. The purpose, as I said, about this video is to take you through what the guidance means to you. On other videos, you'll note that I've made reference to statute. Statute is something that is enacted by Parliament. It's the highest law of the land, and it goes through two processes before it gets royal assent from the Queen. This has happened so quickly that we have interim measures, and those interim measures are in the form of a statutory instrument. The Health Protection, do excuse that noise, the Health Protection Coronavirus Business Closure England Regulations 2020 now make it an offence for any company that is found not to be complying with those regulations, and as a result of that, those companies can face specific sanctions imposed at government level. As you'll all know, please forgive the noise in the background, as I said, as you will all know, the regulations have been enacted to put in safety measures with immediate effect for the simple reason that people in this country are not taking sufficient notice of the lockdown that was requested and is now in place. It's now a requirement to close premises and businesses during the emergency. We know why: social isolation. The issue for the caravan owners is falling under that specific piece of legislation are companies like, shall we say, hotels, B&Bs, places where food and drink is sold, anything that where food is consumed on premises. And effectively, the government is in a very, very tricky situation because it specifically has to order these companies to close down with exceptions. Those exceptions are what you must take into consideration at the moment. I will say this, I've said it on Facebook and I'm saying it here again. For the first time in UK history, caravan owners, whether you reside on your caravan, in your caravan on site permanently, or whether you have a primary residence and your caravan is your secondary residence, you have more rights than you have ever had in the history of your particular industry. And I say that because we have government sanction, i.e. from the very top of our democratic government, we have permission for caravan owners to live permanently in their caravans, at least during this period of lockdown. I say this because we have guidance, which I'll come to in a moment, and then as I said, the legislation that's been enacted. And the reason that I will say that you have the permission is the statutory regulations actually say a person who, without reasonable excuse, contravenes Regulation 2 commits an offence. It's the reasonable excuse that caravan owners need to be aware of. A person who obstructs without reasonable excuse any person carrying out a function under the regulation also commits an offence. What that could mean is if a caravan site was trying to close and a member of the public was trying to stop them closing, it could be said that that person was assisting in the commission of an offence. People who aren't lawyers and people who are lay consumers are getting this all kinds of wrong. Contrary to the information that may be circulating as a result of negative publicity from a group of caravan owners around the country, this is not a Facebook lawyer that you're speaking to, it's a royal lawyer. The only difference is I don't have a practicing certificate. I do have 12 years of experience in this field, and I also have a wealth of expertise when it comes to interpreting changes in legislation. I'm privileged to be able to sit here and give you guidance that you can rely on in these times of crisis to give you a little bit more support in circumstances where you are still feeling threatened that you may need to leave your caravan. Enforcement of restrictions and prosecution, that's Article 4 of the statutory regulations. A person designated by the Secretary of State can take such action as is necessary to enforce a closure or restriction. So what they're saying is a person with authority given by the Secretary of State can come in and enforce the closure of a business. They expire at the period of 6 months, so the government is making quite clear that we only have these regulations in place because we are in such a dire situation within the global economy and amidst the global pandemic. And it specifically states that restaurants, including restaurants and dining rooms in hotels or members clubs, cafes, canteens at a hospital, anything where you can go in, sit down and have food, is to close. Part 2 specifically deals with cinemas, theatres, nightclubs, bingo halls, concert halls, museums and galleries, casinos, betting shops, spas, massage parlours, gyms and other leisure centres. And it says no impact assessment has been prepared for these regulations. In effect, they have had to enact the regulations so quickly that they have not had time to actually think about any potential consequences. That is why the exception to the rule is included within the legislation. This then brings me to the issue of the guidance that's been issued. Now, the reason that we have guidance is because the guidance foresees some of the issues that people who are trying to follow the new legislation may face. And that is directly relevant because, as you found on the breaking news launch that was put out here recently, Park Holidays, you heard it here first, Park Holidays then wrote out and said that you will need to evacuate and go back to your main residence. We are not closing the park, but we don't want it to open. And I then had the telephone call, as was mentioned, with Jonathan Woodmansey, group solicitor for the Park Holidays Group, and he said, read the guidance, we're adhering to the guidance. Now, One of the points that I'll raise here is the specific reference to the guidance. As I said, to keep it concise, we've got the primary legislation, which we don't have yet, but we do have regulations. That is law. We then have the guidance that is detailing what you need to be aware of when trying to interpret and apply those regulations to conduct in your everyday life. It specifically says under the .gov guidance for this specific sector of industry, you've got to look at social distancing. That's par for the course. We need to do that to restrict the movement of this virus. Queue control and everything else is par for the course. I don't need to go into it. The following businesses and premises must remain closed: restaurants, cafes, including workplace canteens, public houses, bars, nightclubs, hotels, bars, members clubs, hair, beauty and nail salons, all retail with exceptions. We then come to the area that's directly relevant to all of you, which is hostels, hotels, hostels, B&Bs, campsites, boarding houses for commercial use, caravan parks and sites for commercial use. Now, let me be clear about this. This is guidance, but the guidance is giving you guidance on the statutory regulations that have been enacted, which are given the power of law in the UK. It specifically states that those companies must close unless exceptions apply. It's the interpretation of those exceptions now that will give you the comfort to know if you are taking a stand that you're supported by law. As you know, supermarkets aren't closed, yet if you read the guidance, it says primarily that they have to close. Why are they an exception? Because the people need the information and the data and the goods that you can get within those supermarkets in order to be able to live. So this guidance is put in place in order to promote life, not cause death. Any park that tells you that they are closing and you are not allowed to live in your caravan is directly breaching the statutory regulations that are in place that are law, for which they could be committing an offence. Second of all, they are flying in the face of the guidance that's been put down by government in order to give all of you people that were all bound by the same regulations the comfort and the knowledge that you need to understand your rights. Caravan parks and sites for commercial uses are those that must close. However, the exception is where people live permanently in caravan parks or are staying in caravan parks as interim abodes where their primary residence is not available. They may continue to do so. Let me put a little bit more meat on those bones. Park Holidays have issued a request for all members of their, we'll call it a congregation, or of their communities per site to fill in a SurveyMonkey questionnaire. I am telling you right now that as far as I understand it, there are no legal requirements in place at the moment. There are no new contracts where you have given them the implied or express right, i.e. an implied right. We've got a contract and we're allowed to change the terms, and you signed it at the beginning to say that you would accede to these terms at a later date, and you have not, as far as I understand it, being asked to sign new terms. The legislation I have just read you does not include the obligation to fill in the SurveyMonkey questionnaire that is being circulated to goodness knows how many members of the public that are customers of Park Holidays, which does not actually require you to fill it in. Telling you that is a legal requirement under these circumstances could be said to represent something that falls under an illegitimate abuse of power. I say that, and I said could. So before anybody starts any accusations about defamatory comments, I'm giving legal advice on a public forum to members of the community who are coming to me with legitimate concerns about possible abuses of power, and amidst great fear that if they do not complete the SurveyMonkey questionnaire that I have been told that they are being told is a legal requirement, they are under fear of being evicted. That cannot happen. Why can it not happen? Because the legislation in place says it can't. As for any other person that is facing the closure of their park, I am here to tell you that the guidance is very clear. If you do not have another abode as a primary residence, You may continue to live in your caravan, even if you live in your caravan permanently. If you have another main residence, but you can't get to it because travel has been restricted under the social distancing measures, you may continue to stay in your caravan. One lady on the Unhappy Caravan Owners Legal Beagle project, a page that was set up with a committee behind me, has stated that she is fearful that she will be asked to leave under threat of eviction because she has another primary residence. There's a key issue in that lady's situation, ladies and gentlemen. She has leukemia. Leukemia falls under a high-risk category. Not only is she immunocompromised, she must stay at home. Home for the present lockdown is her caravan because she is already there. It is quite possible that, bearing in mind that I have contacts, friends and family in Italy who are only now starting to face the stark reality of the impact of COVID-19 as it runs amok, with a lockdown in place that's been in place weeks longer than the UK's, with far more stringent measures in place. If that lady is forced to leave her property, there is a distinct possibility that she could actually contract a virus that will kill her. Is this scaremongering? No, it's fact. And any park that is stating we might not have insurance, we may have to close because we've not got insurance, the guidance is there for a reason. It is giving you any legitimate justification that any company takes to stay open when there is a known category of person that falls under a relevant exemption living on the parks. That means under the new regulations, that company owes a duty to ensure that the park stays open for the purposes of supporting that person living on the caravan site in a caravan. Irrespective of whether there are any requirements in place that would make it good policy for Park Holidays or any other company to actually write out and say, can you tell us whether you live on site or whether you've got another primary residence? With greatest respect, my company was put to proof by Carol Keeble not so long ago when it was felt that I hadn't got a full enough grasp of the information. I managed to get that information together. Why can't Park Holidays? Why can't the other parks? They know, or ought reasonably to have known, at the point of contract, whether you were selling your home to live on site, whether you've got a PO box address. It could be said that they already have all the information that they need at their fingertips by going through their books and records. The books and records of a company are those that help that company to run efficiently. So do I think that there is a legal requirement for you to complete the SurveyMonkey questionnaire? No, I do not, and I will maintain this position until I see a piece of case law or a piece of statute or anything else that proves beyond any form of doubt in these circumstances that you should give that information. They already have it. It is also possibly, and I say this possibly, because on a strategic basis, bearing in mind, since I came to this project 18 months ago, Park Holidays have been put to different standards of proof. One of the key reactions to date has been that they ask you for information that I am suggesting that they ought reasonably to have had from the point that each of you contracted with your holiday park. The same may be said for any holiday park with whom you've done business during the last 6 years, because they're required to hold that data for 6 years according to law. If they are coming back to you at any point, particularly when the business is under duress or under stress from consumer complaints, it could be suggested that they are gathering data for the purposes of analysing what risks they have and whether there are legitimate means to exercise contractual remedies to have a person evicted from site. So, what I'm saying to you, ladies and gentlemen, is you should take great care when giving your information to a party that has no legal basis at the moment, as far as I'm aware, bearing in mind that the legislation was put in place on the 21st of March 2020, and as far as I'm aware, there have been no judicial interpretations of those regulations to date. I do not believe that there is a legal basis for any holiday park to ask you to complete anything where you are putting anything in writing where you potentially incriminate yourself. And I say that specifically to protect all of you. You lived there before the austerity measures were put in place and before the lockdown was put in place, and it was not a requirement then. So why would it need to be a requirement now? The holiday parks are not obliged, as I understand it, to actually owe you a duty of care beyond the basic measures that need to be in place for you to stay in your caravan. There is no reporting requirements that require the companies to report back to government. Nobody is requesting that you give details of your whereabouts, and if that were the case, every homeowner in the UK that owns a second property would be under the exact same obligations. It does not exist. For that reason, I would suggest that you tread with great care if you do not want to face further recriminations at a point in time beyond COVID-19. Second of all, if any of you should be facing the risk of eviction under anything other than that which I have said here, i.e. if you've got a secondary residence and you can go to it, then you ought reasonably to go. The law as it stands amidst the guidance given on lockdown does not preclude you from going back to your main residence. In fact, we've got guidance that says that you ought to do so. It also says that you need to limit your exposure to the virus and limit the possibility that you may have contracted the virus and take it elsewhere. For those reasons, if you have a valid exception, if you have a basis for staying in your caravan, you are entitled at law to exercise that right, and the caravan parks know it. As I said, there is a petition. It's not going to be stalled by going up the parliamentary route. It's not like all the other parliamentary petitions that are in place that are now going up a queue that have to reach 10,000 before people are listening. In actual fact, I maintain caravan owners around the UK have the highest level of protections that they have ever had, because the government during these periods of crisis have written into law and guidance that you are allowed to continue to live on site. The petition that says you need to be included under the Mobile Homes Act, that's something for a later date. Just my opinion. At the moment, arguably, you need to be looking for equal treatment, and the equal treatment that may be represented by the petition, the 38 Degrees petition that's been created by Keith Whitehouse, for which there'll be a link below, is specifically dedicated to raising awareness, to actually putting in place the measures that are being abused. And one of the things that we are talking about with an abuse of powers and conduct that we do not think fits the economic and the very sensitive situation at the moment is the potential that holiday parks are in fact misinterpreting the guidance and abusing their position by asking you to fill in information that could be used against you. These are the situations that petition was designed to capture. These are the things that face and present an immediate risk to your health, not a petition that could be dealt with 6 months down the line. You are safe if you know how to enforce your rights. Stick with it. Please keep coming back to YouTube. Subscribe. You don't need to like it. I don't care whether you like me or hate me, but I am giving you guidance that is the most contemporaneous in the UK about a subject matter that pertains to the roof over your head and a risk to your life and those of your loved ones. If you want more information, please subscribe. Please fill in the petition below and help us keep circulating this. And don't put up with any crap from any holiday park. Yes, they've got obligations, and let me make my position clear. I run a business as well. I understand in these times the businesses are taking a huge hit. But if all of you are wiped out, there won't be a business. So it's in the interests of all of the companies to put corporate greed to one side and work together to protect the lifeblood of the UK economy. All of you. Help me help you. Thanks for your time.